What would you do if you woke up one morning and your backyard was just gone? Not flooded, not overgrown, stolen by your HOA president, who literally moved the boundary stakes overnight so she could advertise lake views from her property listing. Now here's what you need to know right now. She didn't just lose the sale. She lost her house, her board seat, and faced a criminal charge most people don't even know exists. And it all started with one survey flag in the wrong place. But before we get to the part where she completely implodes, you need to understand just how brazen this woman really was. Marcus and Diane bought their lakeside lot in a quiet, planned community in 2019. Modest house, modest people. But their backyard touched the water, and that 20-foot strip of shoreline was worth everything to them. Their neighbor, Karen, HOA president, realtor, and self-appointed queen of the cul-de-sac, had been trying to buy that strip for 2 years. Marcus said no, twice. Therefore, Karen did what entitled people with a little institutional power always do. She stopped asking. Marcus noticed something odd in March. The little orange survey flags that marked his rear property line had moved, not by accident, not by a few inches, by 11 feet, toward his house, which, not coincidentally, gave Karen's backyard a direct waterfront edge. And Karen had just listed her home for sale. Here's the part that'll make your jaw drop. This wasn't even the first time she'd tried something like this, and Marcus was about to find out why. Marcus went to Karen's door the same day, calm, civil. He pointed to the flags and asked what happened. Karen looked him dead in the eye and said, "And I want you to really hear this. The HOA recently commissioned a resurvey of common area boundaries. The results updated several lot lines in this section. It's all perfectly documented." She said it like she was reading a weather report. No flinch, no hesitation. Total performance. Therefore, Marcus did what any rational person would do. He asked for the documentation. Karen told him it would be available at the next board meeting, in 6 weeks. 6 weeks. While her house sat on the market advertising waterfront views that technically belonged to him. Open loop number 1. What documentation? There was none, but Marcus didn't know that yet. Now here's your pattern interrupt, because up to this point this sounds like a property dispute. Annoying, sure, but manageable. What happened next turned it into something else entirely. Marcus pulled his original title survey, his deed, his closing documents from 2019. Every single one confirmed the same rear boundary, 11 feet further back than where those flags now stood. He took photos. He measured. He even overlaid the coordinates. But when he brought this to the HOA board, the board Karen ran, 2 of the 3 members said they had, quote, already reviewed the resurvey and found it valid. The 3rd member went quiet and wouldn't make eye contact. Marcus later found out those 2 board members had both recently used Karen as their real estate agent. So now we have a sitting HOA president using board authority she invented to move a property line, to inflate the value of a home she is actively trying to sell, with board members who owe her favors rubber stamping the whole thing. And her listing? It had already gone live, with lakefront in the description, with photos of Marcus's shoreline, and an asking price $60,000 above her original estimate. But Marcus was done being polite, and what he did next is exactly why this woman's plan didn't just fail, it exploded. Marcus hired a licensed land surveyor, not the HOA's guy, a certified independent firm, and had his property formally resurveyed within the week. The results came back in writing with GPS coordinates, legal descriptions, the whole stack. His boundary was exactly where his original deed said it was. The flags Karen planted were 11.3 feet inside his legal property. Therefore, Marcus did two things simultaneously. First, he sent a certified letter to Karen and the board with the survey results, a formal demand to restore the boundary markers, and a notice that her property listing contained materially false information about lot lines and waterfront access. Second, and this is the part Karen did not see coming, he filed a complaint with the State Real Estate Licensing Board. Because Karen wasn't just an HOA bully, she was a licensed realtor. And knowingly listing false property descriptions is not a neighborhood dispute. It is a licensing violation. Potentially fraud. Open loop closed. But here is where it gets truly wild. While Marcus was doing all of this quietly and methodically, Karen escalated. She sent a letter to Marcus through the HOA threatening him with fines for interfering with an official board survey process. She also called his mortgage lender, and suggested his property dimensions might be in dispute, which she implied could affect his loan terms. She was trying to weaponize his bank against him, to pressure him into dropping it. Therefore, Marcus added a second complaint, this one to the State Attorney General's Consumer Protection Office. Because contacting someone's lender with fabricated property disputes to coerce them into silence has a name. It's called tortious interference. And in some jurisdictions, depending on intent, it edges toward criminal harassment and extortion. Karen had gone from moving survey flags to potentially committing crimes, and she had done all of it in writing. Every letter, every HOA notice, documented, dated, signed. And then came the day Marcus got a phone call he genuinely did not expect, from the third board member who wouldn't make eye contact. The third board member, a retired school teacher named Pat, called Marcus and told him everything. Karen had pressured the other two members by threatening to report minor HOA violations on their properties if they didn't back her resurvey. Pat had refused. Karen had been using her board position to manipulate, intimidate, and strong-arm neighbors for years. Pat had a folder, dates, incidents, names. Pat submitted that folder to the State Real Estate Board investigator who was already looking into Marcus's complaint. The Real Estate Board suspended Karen's license pending a full investigation. The sale of her home collapsed. The buyers walked when the waterfront claim unraveled, and the listing was flagged. The HOA board called an emergency meeting, and Karen was removed as president by a community vote of 19-2. The Attorney General's office reviewed the lender contact and referred the matter for further review under the state's consumer protection statutes. As of the last update Marcus shared publicly, Karen was facing a civil suit from him for the survey costs, legal fees, and documented interference with his property rights. The boundary markers were restored. His shoreline was his again. And Karen's house eventually sold, without the waterfront description, for $43,000 less than her original ask. Marcus said in a community forum afterward, "I just wanted my backyard back." She turned it into a full legal situation all by herself. Every single escalation Karen made, the fake resurvey, the board pressure, the lender call, became evidence. She built her own case against herself, one documented step at a time. Drop a comment below. Would you have caught the flag move that fast, or would you have missed it? If you own property in an HOA, screenshot this. Know your survey flags, know your deed boundaries, and document everything the moment something feels off. Comment below. Would you have confronted Karen directly or gone straight to a lawyer? I read every single one, And if you want more stories of HOA power trips that completely backfired, subscribe. We post every week. The next one might be worse than this.